All right, today we are diving into a really fascinating Canadian Supreme Court case. It's a story where brand new technology went head-to-head with one of our oldest rights, the right to be left alone in our own homes. This is R.V. Tessling, and it all started with one big question.
And here it is. This is what it all boils down to. Just think about it for a second. Can the police fly a plane over your house, point a special camera at it, and take a picture of its heat signature, all without getting a warrant first? That was the exact puzzle the court had to solve.
So, the piece of tech at the center of all this is called FLIR. The easiest way to think about it is this. A normal camera sees light, but a FLIR camera sees heat. It creates a kind of heat picture that shows which parts of a building are warm and which parts are cool. Now, it's not X-ray vision, it can't see through your walls, but it can see the heat that's escaping from the outside of them.
So how in the world did this heat-seeing camera become the star of a Supreme Court showdown? Well, it all started with an investigation into a man named Walter Tessling.
Here's the timeline. The RCMP got a couple of tips that Mr. Tessling was running a marijuana grow-up, but when they started digging, they hit a wall. Looking at the house, checking the hydro bills, nothing seemed out of the ordinary. So they decided to try something new. They flew a plane over his house with one of those FLIR cameras, no warrant. That heat picture, along with the original tips, was what they used to finally get a search warrant, and sure enough, inside, they found a whole lot of marijuana and a bunch of guns.
Now, you'd think finding all that stuff would be the end of the story, but really, it was just the beginning of this huge legal fight. Everything, and I mean everything, depended on whether that first flyby with the thermal camera was actually legal. Was it an intrusive search of his home, or was it more like just scanning data that was already out in the open?
And that led to two completely opposite arguments. On one hand, Tessling's lawyer said, look, by analyzing heat, you're figuring out what's happening inside my house. That's a search, plain and simple. But the Crown, the government's lawyers, they said, whoa, not so fast. We never went inside. We were just measuring the waste heat that was escaping into the public air. It's no different than seeing smoke coming from a chimney.
This whole fight, this entire case, really hinged on just one line in our Constitution, Section 8 of the Charter. This is our fundamental right to be secure against unreasonable search or seizure. It's basically our constitutional shield against the government snooping around in our lives without a very good reason. And the big question was, did that FLIR stand smash right through that shield?
So, the case makes its way all the way up to the Supreme Court of Canada. Let's try and get inside the judges' heads a little and see how they went about tackling this pretty tricky balancing act between police powers and the privacy of our homes.
To really get where the court was coming from, you have to appreciate just how protected the home is in our legal tradition. I mean, the court itself pointed back to this incredible quote from way back in the 1700s. The idea that your home is your castle, the one place you can be free from the state barging in, that principle was the entire foundation for their decision.
So this brings us to the key legal test they had to apply. It's called the reasonable expectation of privacy. And it's not about what you personally hope is private. It's about what society as a whole would agree is reasonable to keep private. So, was it reasonable for Mr. Tessling to think that the heat patterns on the outside walls of his house would stay private?
To get an answer, the court looked at what they called the totality of the circumstances, which is just a fancy way of saying they looked at the whole picture. They pointed out that, hey, the information was only coming from the outside of the building. The tech was off the wall, not through the wall. Crucially, it couldn't tell you if someone was taking a bath or reading a book or having a private conversation. The court literally called the data mundane and meaningless by itself. All it really said was, something in that house is making heat.
Okay, so after weighing all of that, the court finally came to a decision. So let's get to the verdict and talk about why it still matters so much to us right now.
And in the end, the Supreme Court's decision was clear. Using that specific FLIR camera was not an unconstitutional search. It didn't violate his Section 8 rights. Because the information it gathered was so basic, so limited, and so non-intrusive, they ruled it just didn't cross that line into being a search in the constitutional sense. The evidence was allowed and his conviction was upheld.
But, and this is a really, really big but, the court left the door wide open for the future. They were crystal clear that this ruling was about the technology as it was back in 2004. They basically said future technologies, ones that are more powerful, more revealing, will have to be judged all over again. They were kicking the can down the road, saying we have to deal with this step by step.
And that's exactly where we are today. The kind of tech they were talking about back then seems almost ancient now, doesn't it? We have devices that can do so much more than see a few crude heat splotches. So, that question the Supreme Court left for the future? Well, it's a question for us, right now. In a world with surveillance technology getting more powerful every single day, where do we draw the line now to protect that sacred space we call home? What's the right call today?